I want to bring in our legal and political experts right now. We're just getting a look at some of the exhibits and transcripts from today. So, Elliot Williams, let me start with you. What stands out to you?
A big part of what we saw today was using individuals involved at the Trump Organization who were involved in payroll to help make the case around that which we heard last week. You know, you have to establish as a prosecutor not just the reason for the payments, but what they actually were. And someone has to bring every single document, every single check into evidence and testimony. It's dry, it's not that exciting, but this was critically important to the prosecution, and they had to do it.
And Caitlin Polans, you've been doing a lot of reporting on this. What stands out to you from these transcripts that have just been released?
Well, it's important that one of the people that was there today was a longtime accountant overseeing the accounting department at the Trump Organization. That's Jeff McConney. And what he is showing is the paper trail. He brings that into the evidence, and he also is being highlighted by the defense team when they're cross-examining him, how he has distance to Donald Trump, but also in some ways that highlights how he was not very aware at all of this scheme that prosecutors allege was happening, that was being led by Donald Trump. So here's a little bit of what was said in court as he's under questioning from Emil Bovey, one of the defense attorneys questioning him. During your 30-something plus years at the Trump Organization, you sort of rarely had conversations with President Trump, right? Jeff McConney says very few. And during the instances when you did speak to him, you didn't talk about accounting software, did you? No. And you did not talk to President Trump about the events that you just described in response to Mr. Colangelo's questions, did you? That's a prosecutor. He said, I did not. You did not talk to him about those events in 2016, correct? Jeff McConney said, I did not. Emil Bovey asked him, you did not talk to him about those events in 2017, did you? McConney said, I did not. Bovey said, you did not talk to him about those events in 2018 either. McConney said, I did not. Bovey then asked him, not ever, right? No. And then the question, President Trump did not ask you to do any of the things that you just described in response to the prosecutor's questions, correct? And Jeff McConney, the accountant, said he did not, but he also was the person that was able to show for the jury how there were bank statements of expenses being paid to Keith Davidson, and that Donald Trump had signature authority on making payments and signing checks up until the time he was
the
president.
Controller of the Trump Organization.
That's right.
A major accounting position. And let's talk a little bit about what we just heard, Elliot. How significant is it that McConney didn't have direct conversations with Trump?
I think it's something that we could have anticipated that the defense would have done, and I believe they teased this in their opening statement. And this will be a thread through their case that Michael Cohen himself, the lawyer and fixer, in effect went rogue and carried out these actions by himself, and that Donald Trump did not personally direct the actions. Now, prosecutors are trying to establish that the Trump Organization was run like a small business, and Donald Trump would have known what the reasons for certain payments were. But this is a pretty obvious argument that the defense was going to make, and I think they're going to keep going there.
Jim Trusty, you're a former Trump attorney. Let me read to you something that emerged today in terms of the exhibits that were shown to the jury. And I'll put this up on the screen. This is a bank statement that appears to show Alan Weisselberg, the chief financial officer of the Trump Organization, Alan Weisselberg's handwritten notes calculating the amounts Cohen needs to be reimbursed are handwritten notes. The note shows McConney making that calculation. What's your reaction?
Not much. I mean, look, Elliot refers to this stuff as kind of necessary but boring. And that's true. And again, the fight is not whether NDAs were reached or whether money was paid. The fight is the complicity and the intent when ledgers are entered that say legal services instead of legal services for NDA. Let me just say this, Wolf. It doesn't always turn out to be boring and necessary. In white collar, I've been around federal prosecution for 25 years on both sides. And what you really look for in a white collar case is somebody from the money machine, somebody, a CFO, a comptroller, a CPA, that comes in and says, I was shocked to find out that the client didn't tell me these things, or I told him this would be a bogus deduction if you're doing a tax case. So that's what you're looking for. The key to the kingdom is usually the people that are on the stand today, and they didn't deliver it. They gave kind of, we didn't really know, and we didn't talk to President Trump. That's a friendly cross. That's exactly what you want all the way up until Cohen, is a friendly cross.
David Chalian, you're a political director. How do you think the public at large reacts to all this technical stuff that's emerging today?
I think it's largely washing over them in sort of pre-informed ways. I don't think we've seen any evidence yet that the day-to-day in and out of the trial is having a very substantive impact on the state of the presidential race. I think to what you just heard here, I mean, I think any day like today, where the defense team can effectively cross a prosecution witness and at least perhaps cede reasonable doubt that Donald Trump directed these payments, is a good day for the presumptive Republican nominee. And that, you know, Donald Trump, at the end of the day here, I think that the public is likely going to react to the verdict here and have a response. But prior to that, even with Michael Cohen and Stormy Daniels upcoming, Wolf, I don't think it's going to have a lot of political effect until we know the outcome.
No, let's wait for the outcome. You know, Caitlin Polonz, Judge Merchan gave Trump another very stern warning about violating the gag order he had imposed. Tell us about that.
Yeah, Wolf, this was the 10th time that the judge has found Donald Trump violated the gag order and is being held in contempt of court, being fined $1,000 for each of those violations, commenting on potential witnesses, jurors, others in this case. Judge Merchan said this in court to Donald Trump. This is a judge speaking to a criminal defendant before him.
This is from the transcript, a direct quote.
This is the direct quote of what the judge, he also wrote in an order, but this is what he said in court today. It appears that the $1,000 fines are not serving as a deterrent. Therefore, going forward, this court will have to consider a jail sanction if recommended. Mr. Trump, it's important to understand that the last thing I want to do is to put you in jail. You are the former president of the United States and possibly the next president as well. But at the end of the day, I have a job to do, and part of that job is to protect the dignity of the judicial system and compel respect. So, as much as I do not want to impose a jail sanction, and I have done everything I can to avoid doing so, I want you to understand that I will, if necessary and appropriate.
What do you think it would take, though, for the judge to actually put Trump in jail?
I think it would have to be a flagrant and egregious violation of the gag order. I mean, going after the jury again, going after a non-Michael Cohen witness by name explicitly in a manner that wasn't even a gray area. If you notice today, there were a few different statements. There were 4 of them total, and the judge only sanctioned one of them because it was the only obvious one. It was the statement in which the former president had commented on the jury pool. I think it would really take something like that. I think, you know, a lot of people in the public have this notion that the judge can and sort of ought to just throw the defendant behind bars. And I understand that sentiment. New York law constrains what the judge can do. He has to, number one, he's capped at $1,000. He's capped in the amount of time he can put the defendant in jail. And I think it would require a series of warnings for the reasons the judge laid out there. He could get himself and, frankly, the proceedings in a bunch of trouble if he went too far.
But Elliot, I think the judge went also clearly today outside just what is prescribed by law for him to do. He acknowledged the political reality that this is in right now. I mean, saying something like, you are the former president of the United States and possibly the next president as well, that's attached to the statement that the last thing he would want to do is want to put Donald Trump in jail. He fully was explaining, I think, to Donald Trump, to the broader audience of watching this trial, he understands the very unique circumstances that this defendant presents him, and he is just clearly indicating that that is not a place he wants to go.
You know, Jim, you know Trump. You've worked with him. You used to be his attorney. Do you think he will follow these instructions from the judge or continue to violate?
Well, you know, we went from 9 to 1, so we're doing a lot better in terms of contempt. Look, it's hard to tell. I think that the overarching thing that really concerns me is we're in trial. I mean, the basis for gag orders is typically to protect the jury from some sort of contamination, whether that's intimidation or praise or whatever it may be. This is really more an exercise in courtroom control and ego than it is something that has a practical effect on the trial. And if the judge does go further, and it may be genuinely reluctantly for all the things he said today, it's going to put him in a position where there'll be appellate scrutiny that he might not want. And
it also slow down the trial. I mean, if it's a question of getting this proceeding moving along, locking the defendant up is actually going to mess the whole calendar up.
Makes sense.
For the defendant's own benefit.